Yeah. Okay. So welcome everyone. My name is Ronen Avraham, and I'm the current director of the LLM Parasol LLM International Program. And we have two guests. Our special guest from England is Natasha Hausdorff, but we also have a previous director of the LLM program, Professor Eyal Ben-Venisti, who's going to introduce Natasha. And Professor Ben-Venisti is a professor in international law, the University of Cambridge, fellow and former director, the Lauterbach Center for International Law, and previously professor of law and inaugural director, as I said, of our own Parasol International LLM program at Tel Aviv University. Professor Ben-Venisti is also a member of the Institute de Droit International and of the Israeli Academy of Science and Humanities. And most recently, and something we're all very proud of, Professor Ben-Venisti was a counsel for the State of Israel in the case of South Africa versus Israel at the International Court of Justice just last week. So thank you, Natasha, for joining us, and thank you, Eyal, Professor Ben-Venisti, for agreeing to introduce Natasha. So the microphone is yours. Oh, before then, I forgot. I want to, for those of you who don't know what the LLM program is about, so I'm going to share with you less than 3 minutes long short clip about our LLM program. We have some alumni here. Natasha Hausdorff is one of our alumni, so bear with us for 3 minutes and we'll be back. So let me share the screen, and then I'm going to pass the microphone to Professor Ben-Venisti. Hold on a second. I want to do it with the audio correctly.
I knew I wanted to do an international LLM, and I started to look around at some of the programs, and immediately the strong focus on international business transactions at Tel Aviv jumped out at me.
When I was searching for the program, Israel was my first choice, as I really wanted to explore this country and to feel what it means to live here.
There are many tracks on the program. There is technology, business, human rights.
This university enjoys an excellent reputation and attracts outstanding professors.
Like I finished the law and technology track, so you feel more ready to get into the startup nation, and maybe you can work as a lawyer in a law firm. You can pursue a PhD, as I did.
For me, it was fascinating to learn from not only from professors, but also from practitioners, partners at major law firms.
Israel, specifically Tel Aviv, is a very good place to learn, business law, because it's the startup capital of the world.
It's full of energy, creativity, innovation, and everything.
This is where Startup Nation is. This is where the startup scene is in Israel.
People, atmosphere, classrooms, everything is perfect here.
There were people who were getting their second masters, there were people who were already working, who had a lot of experience in their field of work.
A lot of cultural dynamics and a lot of different views.
So having an international LLM program allows you to learn more about the world, have connections with students from all over the world.
There was such an academic level that I've never seen before in any other academic institutions that I've studied.
You get to study not only from established professors in the law faculty, but also from practitioners and activists who are immersed in social issues that sit at the heart of Israeli society.
Campus life is exceptional.
Nowhere else is having the beach so close. Being able to just go to the beach and have some drinks and go into the city.
It's been amazing so far, and I'm really sad when I think about leaving.
Your Mediterranean gateway to global excellence.
Here you will learn with the best students in the world, from the best professors in the world, in one of the best cities in the world. Join us.
The program offers a unique opportunity to combine the studies of doctrine, theory, and practice in a country which is one of the most interesting places to study human rights. and in a country which is full of innovation and technology.
Okay. All right. So, without further ado, Professor Eyal Ben-Venisti, the microphone is yours.
Thank you, Ronen. So it's a great pleasure to introduce to you Natasha Hausdorff. Natasha is a barrister based in London. She's a distinguished alumna of our LLM program. I think you graduated from the first cohort in class of 2015, 2016, and I was fortunate to have you as my student in my laws of armed conflict or international humanitarian law class, and I still remember your interventions and from which I learned a lot already then. Natasha has a law degree from Oxford, and later on she was also a fellow at the National Security Law Program at Columbia Law School. Natasha practiced at Skadden Arps, working on complex international disputes and regulatory matters, both in London and Brussels. And after graduating from the LLM program at Tel Aviv, she clerked with the Chief Justice of the Israeli Supreme Court, Miriam Naor. Nowadays, in addition to practicing as a barrister, Natasha serves as a legal director of the UK Lawyers for Israel Charity Trust, where she discusses matters of international law and other issues concerning Israel, and is able to refute all kinds of misinformations about Israel. She lectures frequently on international law, foreign affairs, national security policy, and among other things, she addressed the UN Human Rights Council in Geneva, the Finnish Parliament in Helsinki, the Czech Parliament in Prague, and multiple times in the US House of Parliament and House of Lords. And it's, for me, watching Natasha giving her talks also over video clips that you see, or in interviews in BBC and other channels, gives me great pride to see how wonderfully she's able to present clear and thoughtful and accurate views about and comprehensive views about international law, things that I understand a bit. And she's always and I remember our discussions, and always we sometimes had arguments, and most of them she won. So now, Natasha, the floor is yours.
I can't tell you how grateful I am for that introduction, Eyal, and it's a real honor to be here and to be introduced by you. I have extremely fond memories of my year at Tel Aviv University. I have to take issue with the promo video, though. One of the best cities in the world is definitely doing Tel Aviv down. So I'm extremely jealous of the participants who are currently on the program, despite being in Israel in these very difficult times. And I'm also extremely grateful for the opportunity to study under Professor Ben-Venisti and others at Tel Aviv University, and to focus in my time at Tel Aviv University on some of the more complex issues in the law of armed conflict. With the benefit of so many think tanks, INSS, of course, is around the corner from the campus. There are many experts that we were able to engage with while I was at the university working on similar issues, many of whom actually I've subsequently shared platforms with at various conferences around the world. So it really is a hub for international law, as well as, of course, the technology programs. But it factors significantly, I think, that Israel has been for some time at the forefront of many of the most critical challenges in applying the laws of armed conflict to extremely complex, challenging environments, urban warfare environments, asymmetric warfare environments in which Israel is contending with not just one enemy, but multiple enemies who not only fail to comply with the laws of armed conflict at their end, but actually as a modus operandi use their breaches of international law and their violations of the law of armed conflict to their advantage in order to progress their own agendas against Israel. And I think that certainly my experiences in the US, in the academy there, reaffirmed how important the Israeli perspective is on debates in international law and the development of international law, especially in armed conflict, because, and I'm sure that there are many on this program who will be familiar with the origins of the modern law of armed conflict and its development. But as with any legal system, it is a living, breathing beast, and it is constantly having to evolve to grapple with new and modern challenges. And one of the parallel focuses of my time at Columbia University was to focus on cyber and how the laws of armed conflict were going to potentially evolve to take into account the new challenges in that particular arena as well. So with that overview, I suppose, as to the academic interest I've had for some time in the laws of armed conflict and specifically in Israel's engagement with them, I hope that potentially sets some of the scene. But the second aspect that pertains to this title, Lawfare against Israel and Iron Swords, speaks to another part of this equation. Because it's not just that Israel is at the forefront of these very tricky challenges in navigating how one upholds the key rules and principles in the law of armed conflict in very much unprecedented circumstances in many cases. There is also another factor here, and that is lawfare. Lawfare is an abuse of legal processes and an abuse of law. As in the context in which I use it, I appreciate it's a term that's had many different definitions. Sometimes they're at variance of each other, but I see it as a negative phenomenon. And it's not negative simply because it leads to aberrations and negative legal outcomes, ones that are contrary in any particular instance to what the proper and appropriate, just, lawful outcome ought to be. But I think lawfare is particularly pernicious because it puts at risk the legal system itself, where it's deployed. It seeks to jeopardize rule of law and the credibility of legal processes where it is deployed. And we've seen one very recent example last week in which I anticipate there'll be opportunity for questions and answers, and I hope also that Professor Ben-Veniste will feel able to speak to his own experiences, because seeing him participate in Israel's defense in The Hague was a moment of great pride for me as a former student. But I know that the robustness and thoroughness of Israel's response on Friday last week benefited tremendously from input across the board. The team that participated and prepared Israel's response was really second to none. And it was, again, I say with a great sense of pride and optimism that I viewed the submissions on Friday that were made. So this is the second aspect of the phenomenon that I think that we're seeing really come to a head now. lawfare and how it has been used to attack Israel. Why is this, specifically in Israel's case? Well, I'm reminded of an op-ed that appeared in 2011 by Mahmoud Abbas. He's still the president of the Palestinian Authority. And writing in the New York Times over a decade ago, he called for the internationalization of the conflict as a legal, not just a political matter. And this article accompanied the admission of the so-called State of Palestine to observer member status at the United Nations. And the article was seeking to use international legal fora, including the International Criminal Court, the International Court of Justice, the UN Human Rights Council, and other UN bodies, in order to advance an agenda against Israel. Now, lawfare, of course, is very similar to warfare, but reading that piece, it struck me that there was a general realization and an acceptance that Israel's enemies would not be victorious against it militarily. The idea of defeating the state of Israel, pushing the Jews into the sea, wiping Israel off of the map. Although we still hear frequently refrains, especially from around the Arab world along those lines, I think the vast majority of Israel's detractors recognize ultimately that that is not achievable. And so the switch from warfare to lawfare has been to seek to use international legal fora in particular to promote the delegitimization of Israel and legal attacks upon it. This is not a new phenomenon. It has been the work of decades, and we have seen armies of NGOs, extremely well funded, promoting this particular agenda in concert, unfortunately, with significant elements of the academy. Now, one aspect of the last few months that seems to have shocked many in the international community has been the level of anti-Semitism across campuses. And I know especially in the United States, this has had serious repercussions. But what seems to be still overlooked is the manner in which Israel is discussed in academic circles and in academic publications. And the lawfare contingent of that, unfortunately, goes hand in hand with other aspects of delegitimization of Israel, the narratives of colonialism, of oppression, and the increasing formation of specific programs and courses of study to focus specifically on that agenda ought to give us pause for concern. Again, this is all by way of scene setting, but it seems to me that Lord Jonathan Sacks, the former chief rabbi of the United Kingdom, the late, great Jonathan Sacks, when he talked about the evolution of anti-Semitism, he put his finger on the nub of the problem. Rabbi Sacks explained that in the Middle Ages, when the hatred of the Jews manifested itself as a hatred against their religion, that was a time when religion was the order of the day. And the blood libels, the ancient blood libels, that Jews would kill Christian children to use their blood to make matzah or in religious rituals, they were extremely widely held beliefs. When science took over from religion, Rabbi Sacks explained that the pseudoscience of eugenics was used by the Nazis to justify a hatred of Jews as a race. And Rabbi Sacks explained that today science had been overtaken by international law and human rights as the orders of the day. And so the current abuses against Israel, the blood libels, have a new formation. That virus has mutated once again. And we see the terminology that is deployed against Israel, legal terminology, but ultimately political words masquerading as legal terms, ethnic cleansing, occupation, colonialism, apartheid, war crimes. And when one understands the realities both of Israel as a state and the IDF as a fighting force, it's clear that those blood libels, those canards, and even now the allegation of genocide, as we heard South Africa advancing at the International Court of Justice, it's clear to anyone who knows the realities of the situation that they are libels, fabrications. But they have first been repeated so frequently, and second, been the subject of so many reports. Of course, the libel of apartheid is featured prominently in reports by Human Rights Watch and Amnesty International. Also, UN bodies that are adopting this terminology and promoting this lawfare. And we see it, of course, also in the context of UN Special Rapporteur reports. And this ecosystem of lawfare has led in many respects to what we saw last week at the International Court of Justice. It is a vicious cycle, but the application to the ICJ plays a very significant part in this process, because up until now we have seen UN bodies putting out reports that South Africa has relied on extensively throughout its 84-page submission and the submissions that were made before the court last week. And we have UN Special Rapporteur reports and other NGOs that contribute to the falsification of many of these allegations. But given the stamp of approval by an international legal body, such as the International Court of Justice, those fabrications and that faux evidence will take on an even greater mantle and will doubtless be deployed against Israel and individual Israelis, even in domestic courts and individual state jurisdictions. And that is something I think that it's important to be especially mindful of. Again, this is not new. This has been a key part of the agenda and the process of lawfare. And what we've seen at the International Court of Justice is only one part. The recent case is only one part of what has been happening at that court. It may be apparent to most of our audience, but it's important to recognize that there are two types of cases that appear in front of the International Court of Justice. One type is of the contentious nature, so the case that South Africa has brought against Israel. But the court also sits in an advisory capacity. And in December 2020, the General Assembly of the United Nations posed a series of questions to the International Court of Justice with respect to Israel. Again, our audience may be familiar with a previous advisory opinion produced by the court, the so-called Wall opinion from 2004, which assessed Israel's security barrier that was built at a time when Israel was suffering waves of suicide bombings and terror attacks, when discotheques and markets and cafes and restaurants and buses were being blown up. As a result of that wave of terror, the security barrier was built and by all accounts, of course, entirely successful in defeating that form of terrorism. But when the International Court of Justice was asked to opine on the legality of the barrier, the reasons for it, the security need, the suicide bombing context were all but absent from the court's decision. And in fact, another former Supreme Court justice, president of the Supreme Court, Aaron Barak, wrote a very interesting, I think, analysis of the ICJ determination and compared it to the reasoning of the Supreme Court sitting as the High Court of Justice in the Elon Moreh case, where the court had acknowledged the security need and the reasons and the justification for the existence of the barrier, but had analysed that and weighed up those security interests against the interests of individual Palestinians who might have been impacted by the choice of route, and going bit by bit along the route of the barrier, had made its assessment of what the court considered to be lawful or unlawful, but with the proper context and provided with the proper information, which the ICJ simply did not have. When one compares that 2004 opinion with the one that has been requested of the court more recently, just over a year ago, UK Lawyers for Israel, which is an organisation I've been very privileged to volunteer with for a little over a decade, we put in a submission to the International Court of Justice along with an international organisation called LNet. And one of the key points that we raised, which I'm given to understand hasn't featured in any of the other submissions before the court, is to caution the court about the information that it has before it, because it is so partisan, misleading, because these UN reports do not provide the full picture, and caution the court in particular not to follow the course that the International Court of Justice adopted in 2004. And to make a decision based on that misrepresentative information. And we'll see what happens with that advisory opinion. It was unprecedented, the request that was made by the General Assembly to the court, in my opinion, in that rather than seeking a legal ruling on contentious questions of international law, what we saw from the General Assembly was a plethora of allegations against Israel, of having violated the Palestinians' right to self-determination, of having committed various other crimes. And rather than actually asking the court to opine on whether or not that was an accurate description, or whether or not those allegations were well-founded, the General Assembly simply asked the court, what were the legal repercussions of the fait accompli, that this shopping list of allegations that the court put, that the General Assembly put towards the court. I haven't seen that in any other case before. It is obviously deeply, deeply unsatisfactory, but it is very clearly in pursuit of this BDS agenda, seeking to obtain an indication from the court that the proper response, the proper ramifications, legal consequences of what it is that is alleged would be sanctions against Israel. And this is, of course, part and parcel of South Africa's agenda and the application of the term apartheid to Israel also. I think the contentious case that we've seen in terms of South Africa's application against Israel is even more egregious. The allegation of genocide is unfathomable and deeply ironic in the context where, of course, this was a term coined by Raphael Lemkin in the aftermath of the Second World War to try and give a lexicon to what had been perpetrated against the Jewish people. This crime, which at its essence is the intention to destroy a group of people because of who they are, to seek to invert that and to use it against the victims of actual acts of genocide, which were perpetrated on the 7th of October, is deeply, profoundly wrong, troubling. And the fact that we have now seen both the United States and the UK come out with strong statements against it, and now Germany also making clear that it will provide submissions on Israel's behalf at the substantive stage of these proceedings, if they should go that far, is significant, because we have law-abiding countries that uphold the rule of law that are clearly deeply concerned by the abuse that South Africa is putting the International Court of Justice to. Undoubtedly, it is in a position to do that because of some of the recent case law. The Myanmar case, the Russia-Ukraine case vis-a-vis provisional measures under the Genocide Convention. And it is because the court has decided, the International Court of Justice still has decided this low bar of plausibility for provisional measures. And because of this library of damning material, fabricated material against Israel produced by that army of NGOs that I mentioned, that the stars have aligned, and South Africa feels able to contend at the ICJ in the manner that they have. There were a couple of interesting nuggets that came out, I think, of the oral hearings that weren't necessarily publicly known before. I mean, apart from calling out the utter nonsense of the allegations and also putting forward robust evidence of all of the measures that Israel takes to protect Palestinian civilian lives and to provide humanitarian assistance, which put the lie to South Africa's allegations, there are also important technical issues that were raised. So, for example, the communication and correspondence that occurred before South Africa's application between the parties, the question of whether there is a properly formed dispute between the parties. And it was clear from the submissions on Friday that Israel has alleged that South Africa has in fact misled the court as to what communications were possible before it brought its application, so that its application is ultimately premature and the court would have no jurisdiction to hear it. All of these issues have to, of course, be considered by the court in accordance with Israel's submissions. But I'm hopeful that the International Court of Justice may at least not be entirely susceptible to this lawfare campaign and may still maintain some credibility as an international court. If we compare it, and perhaps I can end with some of these remarks and we'll open up to questions, but if we compare it, unfortunately, with where the International Criminal Court has got to, there we see lawfare initiatives against Israel, which have reached another level of intensity and which are undoubtedly going to play a significant role in the context of our title, which is Lawfare against Israel in Iron Swords. The International Criminal Court, again, UK Lawyers for Israel made a submission on the question of jurisdiction, which came before Pretrial Chamber 1 in this case, under a previous prosecutor at the ICC, Fatou Bensouda, who contended that despite Israel not being a party to the Rome Statute, there was in fact jurisdiction to investigate potentially Israelis for alleged war crimes. Come on to some of the specifics of that in a moment, on the basis that the state of Palestine, so-called, purported to join the court. Now, there are a long shopping list of difficulties with the jurisdictional claims that were advanced by the prosecutor in that case and the legal acrobatics, if I may be permitted to say so, that she engaged in terms of the submissions she made to Pretrial Chamber 1. There was a very courageous dissent from Judge Kovacs in that case, but ultimately, it's extremely concerning that Pretrial Chamber 1 provisionally ruled in the prosecutor's favour on jurisdiction, despite Israel not being a party to the Rome Statute. And there are good reasons that Israel never joined the Rome Statute, similar, no doubt, to the reasons that the United States didn't join the Rome Statute, because despite both of those countries being very involved in initiatives to form the International Criminal Court in the first place, and contributed significantly to some of the drafting of that court's governing statute, it became clear in, for example, with respect to some of the crimes in Article 8 and the redrafting of, in particular, the crime of transfer, forced transfer of people, with the insertion, for example, of the words directly or indirectly. It became clear, I think, at that juncture that there were those that wished to use this court for political purposes rather than legal ones. And we've seen that despite the United States and Israel not joining, and despite the limitations, therefore, on the court's jurisdiction, it is seeking to circumvent those. And I was in Israel in December when the new prosecutor, Karim Khan, visited and met with families of hostages. And I was extremely concerned that despite the lack of jurisdiction and Israel's consistent position that the ICC has no jurisdiction, Karim Khan was nonetheless seeking to advance the court's agenda vis-a-vis Israel. that can only spell trouble, unfortunately, especially in light of so much of the material that is being put in front of the International Criminal Court, again, of the same nature, the fabricated allegations and faux evidence that unfortunately is churning through the system and is seeking that judicial stamp of approval, in that case, from the ICC in order to be deployed against Israeli individuals. In the case of the ICC, it's a court that has jurisdiction over individuals and crimes committed by them, as opposed to the ICJ, which of course has jurisdiction over states. So that is a little bit of an overview of some of the key challenges. When we compare it to the reality of Israel's initiatives, especially in the law of armed conflict, this is where I think that the real frustration lies, because the facts of the measures that Israel takes, the lengths that it goes to protect the civilian population in Gaza, and its track record in doing so across previous conflicts is all but lost from international discourse and the media coverage of this situation. There is an initiative, a group called the High Level Military Group, which I commend to our audience, who have conducted a series of analyses of previous conflicts in Gaza and produced a series of reports. Colonel Richard Kemp, who is a British former army officer, the former commander of British forces in Afghanistan, a member of Cobra here. He has taken a leading role in that initiative and also been very clear on the lengths that Israel goes to uphold international law. He has said Israel is the most moral army in the history of warfare. And the reason he has said that is because, in addition to the basic requirements of the law of armed conflict, the principle of necessity, the principle of proportionality, the principle of distinction, and the importance of taking precautions, Israel, in fact, goes well above what is required by international law. The warnings that it issues to civilians, of course, also warning Hamas and other Palestinian terrorist organizations of incoming attacks. The leaflets that it drops, the telephone messages, telephone calls, text messages, and the facilitation of humanitarian corridors, where the IDF has been protecting fleeing civilians from Hamas who are firing on them. We don't even get to the point where we talk about Hamas's violations and its use of human shields. But if we just focus on Israel's actions and Israel's conduct and the proportionality analysis that is conducted by the Military Advocate General Corps, who sit outside of the chain of command in the IDF under the authority of the Attorney General, so that they can make strike-by-strike calls on a proportionality assessment. All of this is, of course, ultimately lost in the international discourse, and those canards and those blood libels abound. And I think we as lawyers have a responsibility. If we are not subject to this onslaught of misinformation, and we know the truth of the matter, then I think we also have a responsibility to push back against the misrepresentations, to call out the falsehoods, and push back against the abuse of international law. Not just a responsibility of those who have either lived in Israel, studied in Israel, or have their eyes open to the realities there, but also anyone who is a legal professional. In our practice, and I've qualified both as a solicitor and a barrister, there is an expectation that one upholds the law, the values of the rule of law. And as an officer of the court, I would argue that that responsibility applies not just when you are in front of a judge, but also in the broader context of the application of the law to these sorts of issues. It's a responsibility I've always taken very seriously, and it's what I suppose ultimately drives me to engage in these issues. And I'm extremely excited to be able to take your questions, and I would be absolutely delighted and honoured if there are additional people in the audience who would like to get involved with initiatives at UK Lawyers for Israel, simply lend their voice to pushing back against the lawfare and the misrepresentations. thank you very much for having me. It's a real honor, as I say.
Awesome. Thank you so much. Before we open up the floor for questions, Eyal, would you like to comment or say something or ask a question or whatever? I'll give you the first right of refusal.
Thank you. Listening with great attention to Natasha's presentation. I was struck by the link that you mentioned by Jonathan Sachs made between the blood libel and international. I certainly felt that after October 7th, I mean, it's my personal feeling that after October 7th, I expected more international law colleagues to speak against the Hamas attacks, and I was disappointed that they were not. And the other thing I would like to mention in the submission by South Africa, both in the written statement and in the presentation before the court on Thursday, they did not refer only to the alleged genocide, but they refer to the state of Israel as an illegal entity that is exercising apartheid since its creation in 1948. That's my intervention. Thank you.
And I think that's extremely telling, along with the long list of reports that were cited that go back probably at least a decade, if not more, and that make many more accusations than just that canard of genocide. Of course, genocide was specifically chosen in order to provide the hook at the International Court of Justice because Israel and South Africa are parties to the convention. But more than just the case and the outcome that South Africa is seeking to achieve vis-a-vis its application for provisional measures, what I think we saw on Thursday was just a PR exercise.
Yeah,
it was a display to the world, and in that respect it has been successful. What was being discussed that week was Israel's genocide. Despite it having no basis in reality. And that is unfortunately a key component of lawfare and of the abuse of international legal fora. It's to provide that propaganda base for international media coverage.
Yeah, I agree with you. I think it was a great spectacle. It was a PR show, and even though Israel, in my unbiased opinion, was much better, still, I think the harm is huge. I have tons of questions for you, but I want to give the guests here the chance. So if you want to ask a question, please raise your hand, virtual hand. I see there's a question from Lindsay Cass. Go ahead, sir, or ma'am.
Hello. Yeah, it's actually me piggybacking here on Lindsay's Zoom. My name is Martin Pillane. Natasha, I've got a question in respect of advisory opinions. And obviously on the issue of lawfare, it seems that in recent years we have seen questions being formulated that are deliberately formulated on contentious matters. So I'm thinking about obviously the war case, but also Kosovo and the Chagos case. I'd be interested in your view as to whether that's a concerning development. Is it a way of getting contentious cases by the back door in front of the ICJ? And of course, is it really an attempt to give the ICJ jurisdiction in a case where, in reality, the interested state itself wouldn't consent to adjudication? And I suppose so your view on that, I'd be grateful to hear. And I suppose the follow-up question is really what could be done about it. I'm conscious that, in theory, the court could decline to give an opinion. And I know that's perhaps more theoretical than real. But I'm conscious that, for instance, I think in one of the dissenting opinions in the Chagos case, that was certainly an outcome that was being ventilated.
Yes.
So I'd be interested on your view on those 2 points. Thank you.
Let me add a follow-up question to the previous one, because I think it's related. When you discuss what's going to happen, I wonder if you have a view about the possible intermediary injunction that may or may not be given. What are the chances, and which ones exactly in your view? I know it's guessing, and we don't like to guess, but still do your best.
So I think it's absolutely right that there has been overreach by the International Court of Justice, which is contributing to the Lawfare initiatives. And one key indicator of that, and it is not a positive indicator, is that I believe on the 23rd of May last year, 2023, Iran rejoined the compulsory jurisdiction of the court. What does that tell us? Except that the foremost state sponsor of terror may be seeking to use the court in the not too distant future to its own advantage. That is chilling, and no doubt also a contributing factor in the robust position that we have seen the UK, Germany, and the US adopt vis-a-vis South Africa's application. I think the answer to your first question is yes. That overreach that I mentioned exists in the context of purporting to give advisory opinions on cases where it is inappropriate. And there is a clear distinction between the contentious cases and advisory opinions for that reason. It also exists in the lowering of the bar vis-a-vis provisional measures, the threshold of plausibility. I think is also dangerous overreach by the court, and is encouraging applications of this nature. Vis-a-vis Chagos, of course, I think Israel actually intervened, made submissions in support of the United Kingdom in that case, and so we'll see if the UK returns the favour here. But it is important that one sees law-abiding states such as the UK, Israel, Germany, the US, having similar concerns about the direction of travel of the court, of it intervening in cases through this sort of backdoor, as you say, pseudo hearing contentious cases in the context of an advisory opinion. I mean, it couldn't have been more controversial, the sorts of issues that the court opined on in the Wall opinion, or indeed those that are before it in the context of the General Assembly's resolution December 2022. And the saving grace, perhaps, is that International Court of Justice advisory opinions are not legally binding, but they are authoritative, and they are, as the Wall opinion was, deployed, especially by Israel's detractors. So that is of significant concern. I'm not a betting person, so my, giving odds on what the court is going to do is something that I'm going to refrain from engaging with. But perhaps I can say this: if all is lost at the International Court of Justice, and despite this meritless application, and despite the very clear, robust response that Israel gave, and despite the clear issues before the court and the problems with it engaging, if the court does not acquiesce to Israel's request to dismiss the application and remove the case from the list, and if it orders provisional measures, the first one being sought by South Africa is that Israel immediately cease its operation in Gaza. What does that mean? Is the International Court of Justice really going to rule that Israel is deprived of its inherent right to self-defense? This is not a right that is bestowed by international law. It is a right that is so fundamental it is inherent. It is recognized as inherent by Article 51 of the UN Charter. No one can bestow or take away that right and that duty. Every state's duty and responsibility, the highest responsibility of keeping its citizens safe. Not only that, but if we consider that under the Genocide Convention and the requirement to prevent and punish genocide, Israel is also under an obligation under that very convention to eradicate Hamas, to make sure that the 7th of October can never happen again, against the clear, repeated declarations by the Hamas leadership that they will intend to repeat the 7th of October over and over again. What world are we living in if the International Court of Justice can make a preliminary indication of that sort? So I think that if it does, Israel's not going to sit on its hands. It simply cannot. There are rockets, as I know our friends and colleagues in Tel Aviv can attest to, that are continuing to be fired. And Hamas continues. I appreciate that Israel has been extremely successful in the north of the Gaza Strip, but out of an estimated 40,000 Hamas combatants, terrorists, the IDF believes it is eliminated 9,000. We're not quite there yet in terms of defense and removing the threat that Hamas pose. So I cannot see Israel sitting on its hands. So we're left with a situation where the International Court of Justice ultimately loses all credibility. Now, there are academic studies on the frequency with which provisional measures are being upheld, and I believe the latest sort of stats on that are around 50%, which isn't that impressive. It has been decreasing over time, and certainly in controversial cases, the level of adherence and implementation is significantly lower. So we shall have to wait and see. The court has said as soon as possible. Could be weeks, it could be months, but the implications of what it will do, especially vis-a-vis the provisional measures application, are significant, not just for Israel, but critically for the credibility of the court and what the International Court of Justice will look like in the future. What its standing in the international legal order will be.
Sorry, I was muted. Thank you very much. Are there any other questions, or should I just go on with my own questions? Anyone would like to ask anything? Feel free, don't be shy. Okay, so you mentioned before that Iran just joined the convention, and my question to you is, why South Africa, of all countries that could have filed a suit against Israel at Hague, why South Africa?
So I was in South Africa over the summer on a speaking tour on international law, and I engaged with a variety of institutions there. I had one particular experience, which was on an afternoon off. I was staying in Cape Town, next door to the Museum of Contemporary African Art, and I visited. And the first exhibition that I walked into was a homage to Yasser Arafat and the PLO. And Palestinian terrorism. And the thesis was artists against apartheid, artists against Zionism. But the manner in which such a violent agenda had infiltrated even an art gallery was extremely instructive. Unfortunately, the close link between the ANC in South Africa and Palestinian terrorism is well established. And of course, it's not just that. There was a close relationship also with Muammar Gaddafi. There is a deepening relationship with Iran. And the South African government, and I don't say this of the South African people, because I traveled through Johannesburg, Cape Town, and Durban. And so many of the people that I engaged with are staunchly opposed to this. But from a government level, there is the the close connection that it has had for a long time with anti-Israel forces. But there is also the dire situation that the South African government currently finds itself in. Another takeaway from my travels there was load shedding. Because of the levels of corruption, the government can no longer afford to keep the electricity running consistently across the country. And so there are predetermined electricity outages across the country, including the major cities, where the electricity just goes off. So that those that can afford it make sure that they are essentially supplied off of the national grid. The dire domestic situation in South Africa is such that an exercise like this distracts from the failings domestically. And there are many South African politicians and writers and commentators that have been addressing this phenomenon, this issue in the last couple of weeks on precisely those lines, and are extremely critical of the approach that the government has taken. So in those respects, it's not surprising. It's also not surprising, the Durban conference, the Zionism is Racism resolution, one of the more shameful elements of the history of the United Nations. It's not by coincidence, I think, that it took place in Durban. So there has been a significant agenda there for a substantial period of time. And the fact that it seems, if one follows the Israeli submissions on the Friday, that South Africa didn't go through the usual process of engagement with Israel before bringing its application. The nature of the application, the fact that it wasn't just focused on the issue of genocide, but alleged a history of apartheid against Israel lasting over 75 years. So this is an objection to the state of Israel's very existence. We can argue about post-67 and what the situation is, although I would encourage people to argue about that, because again, the received wisdom on Israel's position after 1967 is deeply, deeply problematic as far as I'm concerned. I'll come on to that with your permission just for a few minutes in a moment, if I may. But the position that South Africa has taken on this for a substantial amount of time has been hugely problematic, horrific in many respects. And so its application does seem to have been long in gestation, premature, and as I say, general, as opposed to just focusing on this canard of genocide. The reason I think that there are long-standing problems here with discussion over Israel and even the status of the territory. So we spent most of this session talking about international humanitarian law and the law of armed conflict, but there are other aspects of public international law which are deeply, deeply misrepresented vis-a-vis Israel. And one example is the application of a universal rule of customary international law that determines the borders of a state when it comes into existence, a rule called uti possidetis iuris. It was established, first started to emerge in the 19th century with the withdrawal of the Spanish from South America. It was applied in Asia, in Africa, at the dissolution of the former communist federations. It's applied to generally states emerging from mandates. The mandate for Mesopotamia when it became the Kingdom of Iraq. In all of these cases, the rule that determines the borders of newly emerging states says that the new entity at its declaration of independence takes on the pre-existing administrative lines that preceded it. Well, in Israel's case, after the severance of Transjordan by the British mandate, the eastern boundary ran down the Jordan River to the Red Sea. And when Israel declared independence, it was the only state to establish itself, the only state to emerge out of the British mandate. Absent any agreement to the contrary, the default rule in international law is uti possidetis iuris. So the legal position, it seems to me, is that when Israel came into existence, when Ben-Gurion declared independence in 1948, Israel's eastern border was inherited from the British Mandate. Those administrative lines became Israel's international border. And the principle, the rule of uti possidetis juris was analyzed by the court in it was 1986, the Burkina Faso Mali case, where it talked about why it is that this rule had come into existence. Customary international law, of course, evolves, develops over time, but that rule had come into formation to provide stability, certainty, clean lines, and to prevent fratricidal struggles as a result of uncertainty when states were declaring themselves. Now, of course, immediately after Israel's declaration of independence, it was attacked by its Arab neighbors, and Jordan occupied, critically along the east, eastern Jerusalem and the West Bank, as it then became known, from Israel. But in 1967, when Israel recovered that territory, which Jordan had ethnically cleansed of its Jews, recovered that territory from Jordan, what was its status? The label of occupier has been applied, but if we compare it with a modern example that the world seems to agree on, another application of uti possidetis juris was vis-a-vis the formation of Ukraine. When Ukraine came into existence, it was uti possidetis juris that told the world that Crimea was part of sovereign Ukraine. And that is why the world has been generally of a single voice in accusing Russia of having occupied Crimea from Ukraine. But if Ukraine were to recover Crimea in the current war, in the same way that Israel recovered the West Bank and East Jerusalem from Jordan, would anyone accuse Ukraine of occupying Crimea from Russia? No. Now, there are other factors, of course, at play. Many people cite the partition resolution, which before Israel's declaration of independence sought to partition the mandate. But of course, not only was that rejected by the Arabs, it was never implemented. It was also a General Assembly resolution, a political resolution. The only UN resolutions that have legal clout are particular Security Council resolutions made under Chapter 7. And so, arguing about partition doesn't really take us further. Now, that's not to say, that Israel underlying sovereignty, that the uti possidetis juris boundaries, which were interestingly enough referred back to in both the ceasefire agreements that Israel had with Jordan and with Egypt, and also in the subsequent peace agreements with Jordan and with Egypt, references always back to the mandatory boundary. But that's not to say that that dictates any way forward or any future solution or settlement. It does say, if we are going to apply international law properly, we are going to apply it equally, then we need to be clear about what the status of the territory, the underlying status of the territory is. We cannot have a general rule and an exception for a country that people just don't seem to like very much, or they have some ideological or political opposition to. That's not how any respectable legal system can operate.
Yeah. Sorry, go ahead.
No, and if we're going to uphold the system and the rule of law, then that's there are many examples of not just double standards, but the rule of law being inverted and misapplied vis-a-vis Israel that I think need to be called out.
Yeah, thank you. Well, your last sentence was really fascinating. Something I personally, I'm not an international person, but I'm kind of an avid reader of international, and I've never heard that made before, this argument made before. So I think we'll have to invite you for another webinar, maybe in a few months, to discuss just the status of the West Bank. We have Professor Albin Venisti, who is actually has written a lot about that. I'll be interested in inviting both of you again to discuss this. But I want to thank you very much for the main reason we invited you here, which is to talk about the lawfare against Israel in Iron Swords. Thank you for a fascinating talk with tons of insights. And I want to thank also Albin Venisti for joining us, and everybody else for joining us. And Natasha, please, next time you're in Israel, let us know in advance and come and visit us in our office. I'm sure Marie and Renata and myself and Eyal and many others would love to say hi to you. So please let us know in advance, and I hope you come for good reasons and not to watch all sorts of suspicious international law delegations coming to Israel to investigate us. So thank you again.
Thank you. It's my pleasure to see you all. And I appreciate very much the kind words and the invitation.
Have a good night, everyone. Thank you. Bye-bye.
Thank you.
Bye. Thank you, everyone.